Today's extremely polarizing, controversial Supreme Court decision is built upon a piece of legislation that at its time was so uncontroversial, it passed almost unanimously out of the U.S. Senate.
What this law basically says is that the government should be held to a very high level of proof before it interferes with someone's free exercise of religion. This judgment is shared by the people of the United States as well as by the Congress. We believe strongly that we can never be too vigilant in this work.
Today's Supreme Court decision was not about the First Amendment. It was about a law, the Religious Freedom Restoration Act of 1993.
We all have a shared desire here to protect perhaps the most precious of all American liberties, religious freedom.
RFRA passed Congress with broad bipartisan support and was signed by President Clinton as a direct response to a Supreme Court case argued years earlier.
The Supreme Court takes up the extent to which the law can interfere in religious activities. At issue, Native American tribal ritual, which involves the use of hallucinogenic drugs.
The case was Employment Division v. Smith. It's centered around drugs taken during religious rituals by two Native Americans.
The hallucinogenic drug peyote comes from a cactus plant and has been used in religious ceremonies since the days of the Aztecs. Its use by Native American Indians has been exempted from the narcotics laws by the U.S. government and 15 states. But in Oregon, where peyote is still unlawful, Alfred Smith and Galen Black were fired from their jobs as drug and alcohol counselors and then denied unemployment benefits.
We have a right. The Constitution says we have a right to our religion, our belief.
The case was argued during the peak of the drug war.
The state says there are limits to religious freedom. It says if drug use is allowed, why not polygamy or ritual sacrifice? At a time of increased concern about drugs, the High Court may be reluctant to permit drug use under any circumstances.
In April of 1990, the court ruled that Smith and Black could be prosecuted for the use of drugs in religious rituals, and found that such prosecutions did not violate the First Amendment right to religious freedom. The opinion's author, Justice Antonin Scalia.
I suppose you could say a law against human sacrifice would, would affect only the Aztecs, but I don't know that you have to make you have to make exceptions.
The decision was seen by some as an attack on religious freedom. Enter Democratic Senator Ted Kennedy and Republican Senator Orrin Hatch. The two co-sponsored the Religious Freedom Restoration Act, which slams the Supreme Court for its insufficient deference to religious exercise, saying government should not substantially burden religious exercise without compelling justification. The law created a stronger protection than even what the First Amendment provides. Over the next couple of years, it would be used by a number of different religious groups.
For example, Amish groups had used the law to fight requirements that they put orange safety triangles on their buggies, symbols they found offensive. More mainstream churches used the law to fight zoning rules that stopped them from distributing food.
And while part of the law was overturned in 1997, it has largely been considered uncontroversial. That is until today, when RFRA was cited over 100 times by Justice Samuel Alito in a decision that allows closely held corporations to refuse to pay for insurance coverage for contraception based on that corporation's religious beliefs. But that's a far cry from what those members of Congress voted for back in 1993. Joining me now is Congresswoman Louise Slaughter, Democrat from New York. She was a co-sponsor of the Religious Freedom Restoration Act of 1993. So, Congresswoman, as someone who was a co-sponsor of this legislation, what is your response to Justice Alito telling you you voted for something that made today's ruling possible?
He can tell me that till the cows come home and doesn't make it true. And frankly, I don't know. I think they're hiding behind that Religious Freedom Act. I think the real cause here is the Affordable Care Act. That's the thing that they really couldn't stand for, and that's what's happened. But I'm disappointed but not surprised, because this is the court in Citizens United that told us all that a corporation was a person.
Did you think back in 1993 that you were creating some new set of rights for for-profit corporations to exempt themselves from law?
Of course not. But what they've done, Chris, is they've taken away the religious freedom of their employees. They have to comply with the religious freedom of their employers. Nobody would ever write a law like that in the United States, or most courts would never have upheld anything like that. Let me tell you, this court is different, and Senator Murphy from Connecticut and I are carrying resolutions. We've got quite a number of sponsors and 200 law professors behind us, as well as some organizations, to bring this court under the same code of ethics that all federal judges are under. We have evidence and proof that they spend far too much time in political circles and giving speeches and appearing at political functions, which federal judges cannot do. And since most of them were federal judges, we think it's a darn good idea for them to have this ethics oath as well.
So
I understand that's not going to affect what would happen here today, but I think today was really poor judgment on their part. I thought that Citizens United case was terrible. I learned to sort of expect that. And what do you expect from a court that says that they can hide themselves behind 250 feet away from people who have no right to go there to protest, but 35 feet against a clinic which has been threatened, firebombed, acid thrown at them, everybody harassed, and people have been killed? I know of no such instance of any of that ever happening to the Supreme Court of the United States. But they gave themselves a buffer, 250 feet, 35 feet for a clinic, can't do it. Freedom of speech. The inconsistency of what they're doing is mind-boggling.
Do you think there will be any desire from your colleagues across the aisle? I'm very curious. If the president were to move forward and find some administrative remedy here in which the federal government manages to pay directly for those women who work for employers like Hobby Lobby, what do you anticipate from your Republican colleagues?
Chris, we did all that. What we did, we exempted those religious concerns, and we accommodated everything that we could. And remember that it was nuns in the country that were so wonderful about getting that health care bill passed. We have accommodated. We are not impinging on anybody. A corporation is not a person, even if the Supreme Court says so. And if 90% of the companies in this country are privately held, any one of them could become publicly held whenever they want to. What happens then?
Yeah.
The precedent set here is mind-boggling, and I don't want to keep talking about the Religious Freedom Act because everybody knows that's not what this was based on.
So you just think it was
the Affordable Care Act.
You just think it was the court was looking for something to ground this ruling in, but you're generally distrustful of the good faith of the majority here,
or their legal acumen, one or the other.
So then what do you think?
Maybe both. How about both?
What do you think is next here when you talk about the precedent here? I mean, can you imagine other cases that the Justice Alito sort of hand waves at the possibility of transfusions or vaccination? He says, we're not touching that here, but it seems to open the door.
The fact that he said that this particular judgment right here does not affect those things doesn't mean that a judgment coming in a couple, 3 months for the next term won't.
Right.
They have set a precedent.
Congresswoman Louise Slaughter, thank you so much.
And I find it very dangerous. Thank you very much.
Thank you.